Right, okay, so thank you everyone for joining today's session on tree root liability. Just those of you who weren't here at the start of the call, just to let you know, the call will be recorded. So thank you all for joining this session today. Looking forward to this. So tree root liability, whilst this is an area where the law is relatively settled, not that I want to put a dampener on today's weather, but current weather patterns of decreasing rainfall and warmer, drier summers is likely to lead to an increase in claims activity in this area. And today I have the pleasure of introducing William Sims from our International and Complex Loss Unit, Natasha Howes from McLaren, and Luke Barnes from Zurich Resilience Solutions to talk you through legal liabilities and site investigations for tree root claims, risk management, and enhancing claims defensibility. If you have any questions, hopefully we should have time for those at the end, so please feel free to use the Q&A function by clicking on the button at the top of the screen. And yeah, thank you ever so much again for joining us, and I will hand you over to Will.
Good morning. Thank you everybody for letting me join you today and talk about the subject of legal liability and tree root subsidence claims. What I wanted to talk about in this section really is about legal liability when it comes to tree root subsidence claims. I'm going to focus on some key concepts such as how liability can arise, what's required to prove causation, the importance of foreseeability, and the challenges also posed by shallow foundations. Along the way, I will refer to relevant case law to show how the courts have tackled these issues in practice. So, starting to identify indirect and direct tree root damage. So, there are two main types of claims that can arise from tree roots. First, we have direct tree root damage. This happens when roots themselves physically impact structures, such as pressing against walls or lifting brick driveways and paving slabs. However, today, I'd like to focus on the second type, indirect damage, which is more commonly known as tree root subsidence. This occurs when tree roots draw moisture from the soil, especially shrinkable clay, causing the ground to contract, often during dry periods. Opposite can happen during wetter seasons when the soil expands. When the ground movement happens near buildings, it can lead to structural problems, like cracks appearing in both internal and external walls. In fact, the courts have described this as the impairment of load-bearing capacity of the subsoil. So a good place to start is liability and breach of duty. And tree root claims or subsidence claims generally fall into one of two legal categories. The first is nuisance. This applies when tree roots are spread onto a neighbour's property. In these cases, the focus is on stopping or abating the nuisance caused by the encroaching roots. The second category is negligence. Here, the claim is that as the tree owner, you knew or should have known that your tree was likely to cause damage. Negligence then arises when you fail to maintain your trees properly and don't take reasonable steps to minimize the risk of harm. It is important, however, to remember that legal liability is not the same as causation and vice versa. In other words, it's not just about whether the roots encroached or there was a breach of duty, but also whether that action actually caused the damage in question. So, foreseeability has become a key focus in recent case law, and it is often a point of dispute between the claimants and the defendants when these claims are made. The leading case concerning subsidence and foreseeability is the 2012 Court of Appeal decision in Berendt v Family Mosaic and the London Borough of Islington. Zurich were the insurer for the council and supported Islington's stance that the risk of damage was not reasonably foreseeable. So Mrs. Berendt first noticed damage to their property back in 2004. 5 years later, in 2009, they began legal proceedings seeking compensation for the damage to the home. They submitted evidence which they believed demonstrated that two mature London plane trees on the pavement outside, owned by Islington Council, and a tree in a neighbour's garden owned by Mosaic were responsible for ground movement and the resulting damage to the property. The issue that the Court of Appeal decided upon were: what was the cause of the damage in 2004, and was there a foreseeable risk of damage? In the case, the Court of Appeal was not persuaded by the claimant's experts and found that the evidence did not demonstrate a real risk of damage. There were also other possible causes for the damage, such as vibrations from tunnelling works, including the connection between St Pancras and the Channel Tunnel that was being built to the rear of the claimant's garden, blocked drains and leaking drains which could and did affect the soil conditions. Now, the claimant argued that both defendants should have managed their trees more proactively, either by pollarding, crowning, or other maintenance options that may have been available to them. However, this argument was actually inconsistent with the claimant's own expert's published paper. And Mr. Kelly and his paper, which was titled "Tree-Related Subsidence, Pruning is Not the Answer." Mr. Kelly, in effect, was saying, to avoid tree root subsidence, you have to cut down the tree. Nothing else will work. But yet the claimant was saying, our cases, the local authority and family Mosaic should have in actual fact been pollarding and crowning the tree earlier. Well, you cannot have your cake and eat it. Ultimately, the Court of Appeal concluded that at the time that the damage occurred in 2003 and 2004, neither defendant had any reason to foresee that the trees posed a real risk of harm. The court found that any breach of duty only arose much later, and that was from autumn of 2010 until the trees were finally removed in March 2011. Now, because the majority, if not all, the damage to the property had occurred prior to 2010, the Court of Appeal simply awarded a nominal sum to the claimant for the loss of amenity for that period of 2010 to 2011 only. So the case of Berrant has provided clarification on a number of points. Firstly, liability isn't based on a mere theoretical risk. The defendant must have known or ought to have known that there was a real risk of damage. Secondly, local authorities are not expected to remove all trees to avoid potential claims. They're allowed to manage trees responsibly rather than leaving our streets bare. Thirdly, the proximity of a tree to a property does not equal a real risk. And importantly, the court rejected the idea of a near strict liability which claimants were often arguing for. And the court stated there is no special law for tree root subsidence claims, and foreseeability remains essential. Now, prior to Berrant, it was relatively straightforward for a third party to argue that a local authority should have foreseen the risk of their trees causing damage, especially if the area had clay soil and the trees were near these houses. Now, thanks to the case of Berrant, the threshold is higher. There must be a real and not just a possible risk that the authority was or should have been aware of. So, foreseeability remained an issue, and the case of Robbins v. Bexley gave the court further opportunity to clarify how tree root liability should be or could be assessed. In this case, the claimant's property backed onto Danson Park, which was lined with poplar trees. In 2003, the property suffered damage. Although the nearest poplar tree was 30 metres away and there was other vegetation in the claimant's garden, the court found, based on the evidence, that the poplar trees were indeed the cause. Now, foreseeability, as I say, was a key issue. The poplar trees were in a known hotspot area, with 4 prior documented claims on the same street involving these types of trees from the park. The court concluded that by 1998, the risk of damage for poplars within 35 metres of a property was well documented and clearly foreseeable. Previous claims in the same street had already highlighted the issue, making the risk much more obvious to the council. As you can see, this was a significant difference on the facts in the Berent claim. And in 1998, the advice was clear. Poplars should have a 30% reduction every 3 to 4 years. However, the trees in question were only pruned in 1998 and not again until September of 2006. Because the maintenance schedule wasn't followed, the judge found that the council was negligent and were the view that had the recommended cyclical pruning taken place, the damage would likely have been avoided. Now, this case highlights the importance of having a robust cyclical maintenance regime, especially where there is a known risk. And taking these steps help prevent damage and demonstrate that the foreseeable risks are being managed responsibly as the prudent tree owner. So in summary, Berent tightened the requirements for proving liability, focusing on real and foreseeable risks and not simply the theoretical, while Robbins v. Bexley showed that when risks are well known and maintenance is lacking, liability can be clearly established. Causation is important, and of course it's important to remember that in cases of tree root subsidence, the claimant must prove that a tree roots actually caused the damage to their property. For example, in the case of Patterson and another v. Humberside County Council 1995, the High Court was asked to decide if lime trees were responsible for subsidence. The judge found that it was enough to show that the trees were an effective and substantial cause of the damage, even if they weren't the only cause. This principle is echoed by Lord Justice Tomlinson in the Berent case, where he stated that a tree needs to be an effective and substantial cause of damage, not necessarily the sole or predominant cause. So the key takeaway, that is, as long as the tree roots are a significant contributing factor to the damage, that should be sufficient to establish causation in these cases. However, this does not mean that the defence cannot seek a reduction in the value of a claim due to other contributing factors. Finally, the depth of shallow foundations, as I'm sure you're all aware, is quite often an emotive subject, particularly for the tree owner and also the property owner. The courts have been clear. They apply what's known as the eggshell skull rule. This principle, also used in personal injury cases, means you take your victim as you find them. In other words, if a property is more vulnerable, that doesn't reduce the liability. A leading case on this point is Patterson and another v. Humberside Council. In this case, the court accepted that the building, despite its shallow foundations, had stood the test of time. The judge said the foundations were not so poor that the damage was bound to happen in any event. The property had stood for 100 years. The only reason damage occurred was because of the tree roots. Put simply, but for the roots, there would have been no problem. But before any damage is reported, a defendant might argue that if the home had been built to NHBC guidelines, it wouldn't have been foreseeable that trees posed a real risk. This was confirmed in Siddiqui v. Hillingdon in 2003. The claimant's home was built in the early 1980s. next to a council-owned woodland and later suffered from subsidence damage. All experts agreed that tree roots were to blame. The court made it clear that the developer should have taken account of the clay soil and nearby trees and built the foundations accordingly. Therefore, prior to the actual damage and notice, the council couldn't have possibly foreseen of an issue. However, once a tree owner is made aware of a risk, the eggshell skull rule applies. And at that stage, I think we can all agree that it's not reasonable to do nothing. Proactive steps must be taken. It's also important to note that since 1992, NHBC guidelines have become the industry standard for permanent structures, and I emphasize permanent. But there's still some uncertainty about whether these guidelines apply to conservatories, which are often considered temporary structures for local planning purposes. Now, so far, the courts haven't given a definitive answer, so each claim needs to be judged on its own facts and merits. What I would say, though, in summary, is once on notice of a potential risk, doing something isn't a reasonable option. The but-for test and the eggshell skull rule both play a key role, and the tree owner should act as a reasonable neighbour in taking steps to avoid damage once on notice of a foreseeable and real risk of damage to property that may be caused by that tree. So now, to delve deeper into the topic of causation and site investigation, I'll hand you over to Natasha.
Hello, my name is Natasha Howes and I'm an executive adjuster at McLaren's. It's my pleasure to be here today with you to talk about what technical evidence is considered when dealing with tree root liability claims. As to be expected, when we receive a tree root liability claim, we look to see what evidence has been provided with the allegations by the claimant's solicitors and or the third-party representatives. So first off, we look at what is subsidence. Subsidence is the downward movement of the ground beneath the buildings other than by settlement. In that regard, settlement is the downward movement as a result of the soil being compressed by the weight of the building within 10 years of constructions. We tend to see settlement with new build properties. We then have heave, which is the upward movement of the ground beneath the building as a result of the soil expanding. That is something that we have to be aware of in terms of when requests are made for trees to be removed. So how do trees cause subsidence? Primarily, the roots are in clay soil, so therefore they extract the moisture, causing the soil to dry and shrink, which can then lead to the ground movement and cracking on which a property stands. What does subsidence look like? Subsidence often manifests itself as cracks in walls and floors, particularly around doors and windows. The cracks tend to be wider at the top in a step direction down and then taper off towards the bottom. The cracking can be present in both internal and externally of the property. So in terms of evidence that we request from claimant solicitors or their representatives in order to prove whether the tree is causative or involved in the subsidence to the property, there's a number of documents that we request. One of those is the arboricultural report, which is produced as you would expect by an arboriculturalist, specifically looking at the influence of the trees and the tree itself. We would expect to see in the arboricultural report a description of the site. That is there anything around that could be influencing other than the trees? Is the area flat or is there a slight gradient in the land? We then look at the type of tree. The technical name of the tree will be provided along with its common name, which is much easier for us to understand. And we then get to understand the approximate age of the tree, the spread of the tree, and its height. We also get provided a copy of the plan that's similar to that on the slide in front of you, which shows us where the trees that are alleged to be influencing in the property are situated and sited, and that also enables us to consider if there's any other vegetation in the vicinity that we think may be influencing or further inquiries need to be made of. We would also expect recommendations on tree management to be in the arboriculturalist report, which would be aligned to whether or not the tree needs to be removed in its entirety to abate the nuisance, or whether reduction of the tree would be satisfactory. We tend to find in the arboricultural reports that on occasions other trees are plotted or other vegetation is plotted that may not be specifically interfering on this occasion, however, does have a potential to interfere later on if the tree is allowed to exceed its current dimensions. The arboriculturalist in that regard will say, for example, tree T3 is at a certain height. We recommend that that tree is not allowed to exceed its current dimensions. That is quite important in regards to any future claim that may arise, as whilst those particular trees aren't necessarily implicated now, they could be in the future if they are allowed to exceed that recommended height and spread. And therefore, if they are then implicated, it's very difficult to raise a defence of that it wasn't foreseeable, because arguably the council have been put on notice from that point forward. We then request monitoring results. We do usually ask to see at least 12 months. That enables us to really get a picture of what's happening through that entire season. We expect to see a deep datum point, or otherwise referenced as a stable reference point, which is depicted on the slide in front of you in yellow. And we would expect that to be put on the property away from the area of damage to give a consistent, or this is what the property is doing ordinarily. However, in the area of cracking, we can see a visual pattern. Essentially, what you can see on the slide in front of you is the pink. So as a general rule, we would expect to see a wave-like pattern where the cracks are opening in the summer, closing in the winter, which leads on to the assertion that the tree roots are having an impact. We then look to see the technical reports, which provides information in terms of the property type, semi-detached, detached, whatever it may be, it's documented in there, the age of the property, the size of the property, and whether there's been any recent extensions, etc. It does tend to be on occasions that it is the extension that may be pulling away from the property. So it's good to know when that extension was built, and we can then look to see in terms of building regulations, etc. We also look in the technical report to determine the date the damage was first noticed. This ensures that the claim can still be pursued and it's not subject to the Limitation Act in any way. What damage has been caused? Is it consistent with tree root nuisance, or is it possible that something else is at play? So we would expect to see the area of cracking closest to the tree itself. So if, for example, we've got a situation where the tree is at the rear left-hand corner of the property, but it's the front section of the property that's cracking, not necessarily consistent, and therefore we'd be alive to, okay, what else may be going on here? The technical reports also provide a diagram similar to that, again, that's on the slide, which provides confirmation as to the foundation depth. This information is obtained by the third-party experts excavating a borehole, and that will provide confirmation as to the depth of the foundations to the section of the property which is said to be moving. That can also provide soil analysis results. So there'll be sections of the soil taken away. So we need to determine that the soil is indeed clay, what its plasticity is, whether there's desiccation of that aspect of the soil. Now, typically, if there's desiccation to a depth of at least 2.5 meters, it would more than likely be that it is tree roots causing that desiccation, because we would expect natural desiccation to occur at a much shallower point. We would also expect tree root analysis to be also obtained from the borehole that's been excavated. The roots, if there are any, are taken away and sent to a laboratory, and they then analyse them, and they're able to determine whether they're dead or alive and what species of tree they actually relate to. It needs to be borne in mind that not always will roots be taken from the boreholes. It could be that there's just not any roots in the area. That doesn't mean that the tree isn't implicated or it is causing the subsidence damage to the property. We would also expect to see a drainage report, just ensuring that the drains aren't defective in any way and that there's not an excess of water being pulled out of those drains. And we would then also expect to see a conclusion within the technical report in terms of what that expert considers the cause of the subsidence to be. And obviously, if it's involving the tree, it's more likely to be clay shrinkage subsidence. There's other information that we need to obtain when we're looking at these that's away from the evidence that's provided by the claimant's solicitors and or their representatives, and that's our inquiries with the local authorities. And that is there any other complaints about that tree? Has that tree been subject to other complaints by other parties that say that tree is causing damage maybe to their wall? Was any action taken as a result of those complaints? And have there been any claims by any nearby parties? Is that area of tree a hotspot area? We need to then look at, is there an influence of any other vegetation in someone else's gardens that live nearby? Is the claimant's vegetation in their own garden influencing the damage? We then need to look at whether there's a reasonable system of maintenance inspection by the local authority, and crucially, whether that system is documented. It's very difficult to go back to a claimant solicitor and say, absolutely, there is a system in place, but unfortunately, it's not documented, so we're unable to disclose that. We also then need to consider whether there's any other influencing factors, i.e., is there landslip in the area? Is the property relatively new? So actually, what's being seen is that it's just settling as a new property, and as already mentioned, any drainage defects. We can look to consider historic maps. They're quite good at determining whether or not the area may have been situated on an old mine, which could then be causing the problem. And also the surge years, 2018, 2022 particularly were surge years, and as already alluded to by Daniel, 2025 does seem that it may be a problematic year, but we'll see at the end. What needs to be crucially understood is that even if there is enough evidence to support the fact that the tree is causing or influencing the damage to the property, it doesn't necessarily mean that a liability is attached, which has been discussed by William. What is crucial is that if there is enough evidence and it is on balance causing a problem, that tree action needs to be taken. Essentially, that nuisance needs to be abated. So that is me. So thank you very much for listening, and I pass you over to my colleague, to Luke.
There we go, unmute first. Hi everyone. Lovely to spend a few minutes with you, just talk about the liability aspect of tree roots, how they can affect, how they can impact, and I guess really what we can do to avoid it, avoid an injury to a member of the public, someone within your organisation who might be doing tree works, might be doing the inspections, might be doing the audits, all that good stuff. Really, we just want to reduce risk across the board. Firstly, to highlight, we love trees, and they have a really, really key part in a local area. Things like a skyline, which a tree is a key part of, is priceless. The habitat and nature aspect is literally priceless. And then obviously it provides a nice green aspect, a character to a place. So we keep a tree as long as we can, but trees generally have roots. And when there's roots, that's going to have a knock-on effect to the surrounding area of it. And that's what we're going to try and identify and address firstly. Now, in a physics world, you say if you know where something was and where it is now, you can predict where it's going. Trajectory. With tree roots, to an extent, we can predict where the roots are going to go, but really, because it's an organic thing, it's a living organic thing, it will kind of take its own path. Typically speaking, your softwood trees like conifers and pines and trees like that will grow quite horizontally with tree roots, and your more harder wood trees, which are a bit heavier, will grow more vertically with their roots. So oaks, limes, ash, trees like that, typically. But we can't really predict, we can't say it will continue to grow in this direction because we don't know what's under the ground and we don't know what trees are going to do next. But bearing in mind, the tree roots are its way of getting its dinner and feeding itself. So a tree has a very strong desire to grow outwards and grow downwards. However, when it comes to things like our paths, our walkways, our near buildings, if a tree's near a building, this is what trees typically do. Some trees, and this is a diagram of an oak, by the way, a hardwood tree, but some trees, they're estimated that 95% of their roots can be within the first 30 centimetres of soil. And like anything, the more, how should we word this, volatile the weather becomes, droughts and things like that, the more the tree needs to eat and drink. So the further out it's going to go, and the more to the surface it's going to go. Typically, if you get to the deep areas where a tree root isn't really going to be too much of a problem for us, there's not much water there, there's not much food there, so trees are going to spread out and they're going to keep going in an attempt to get their own dinner. So what does that mean? It means that anything within that zone is potentially going to be affected by the works of the tree roots. So pathways could lift, walkways could become damaged, buildings could become damaged, and subsidence can occur, as has been very well explained, as well as any utilities, data, gas, water, electric, anything like that. If it's kind of in these zones, maybe, just maybe, it will be affected. So how do we do that? Or how do we, what are some of the hazards that we could face? Well, safety hazards, risk of trips, slips and falls. Obviously, if a pathway is uneven, people are more likely to topple over it. And that's even more the case if that pathway is used by members of the public, which might mean people with limited mobility or limited eyesight. It also can be areas that are not well lit. If it's a park, if it's a public area, these can be quite sprawling. They're not going to be, always at least, perfectly lit and illuminated walkways, again, making it more difficult to see a trip hazard caused by a route. As we said, damage to sidewalks, damage to pavements, obstruction to underground utilities. How do you put a cost on things like damage to water piping or an interruption to, say, data? How much could that cost a business or a person in their personal life potentially? Again, these are big costs and it can affect that for sure. Building subsidence and soil shrinkage. I'm not going too much into that, obviously, because it's been well explained, but obviously that's going to be a huge cost potentially. And then hazard to trees from soil compaction and damage. The trees themselves we want to save. So if the roots are desperately trying to get out to get water and get food and feed themselves, and then that means that they start growing under roads and things like that, that damage to the tree can put the tree under great stress. Then they get ill and pick up disorders and diseases, and that can spread to other trees. And that can mean that a whole area like the picture in this road could start to lose their trees, or their trees start dying off. These things can and sadly do happen, and again, what a big cost to that area. There's also legal aspects. Again, it's been really well explained, certainly better than I could explain, but TPOs, we don't want to remove trees unnecessarily, but And because of that, the government's put TPOs in place, tree preservation orders. Again, it's important to do our research. If we think we need to protect an area from the tree roots, we might think, well, let's remove the tree or reduce the tree significantly, but it's worth doing our research as well as local compliance laws. But as with anything, we have a duty of care with what's under our responsibility, financial cost and moral cost. Now, the way I always explain this is my first safety job was in Barnsley. As you can tell, I'm from South Yorkshire originally, very stoic part of the world. And there was this older gentleman called Doug who literally was down the mines in his younger years, lifted incredible weights of materials and really damaged his back. I'm delivering this manual handling training, and I say, how does a bad back affect you all? And Doug, for the first time I think I've ever heard him spoke, said, I can no longer pick my granddaughter up. And the story was that for some reason the parents weren't around. He's got this 4 or 5-year-old granddaughter. When Doug came in from work, she'd go, "Granddad," and go up for a big hug. But he said, I can't bend down anymore. I can't pick my own granddaughter up. And he said the priceless aspect of abusing my body, I guess, from lifting heavy weights badly, I'd change it all if I could. So within our areas, where our parks are, where our trees are, and the roots that can affect buildings and aspects such as that, yep, we've got a legal aspect, and that can be quite damaging if we're taken to court because of something we could have avoided and prevented. The cost, literal cost. Also, there's a reputational aspect. There's a lot of costs. They always call it the iceberg effects, the stuff we can't see under the surface. But it's the priceless aspect of what happens if someone got really, really badly injured or worse because of interactions from tree roots in our local areas, our walkways, our open spaces, things like that. Again, how can we sleep at night? How could we deal with ourselves knowing we could have prevented something that caused a horrendous injury to someone? So that's why we do what we do. That's why we protect people. In this instance, this is why keeping an eye on tree roots and our strategic management and planning is very, very important. So how do we do it? How do we reduce injuries and claims as well? Well, prevention is always key. Risk mitigation is our gold standard. So think of it as a car. There's pre, during and post with a car to drive a car safely. What's your pre stuff? Well, any good driver, and I certainly don't include myself in this, will do a full look around of the car. The brake light's working. Is there enough tread on the tyres? Are the headlights working? All that sort of pre-checks. Is there an MOT on the car? So an expert has done on that car. With our tree roots, we have preventative stuff as well. And that's usually our inspections and our maintenance. And that, obviously, as we inspect a tree, we inspect its roots. So what is that surrounding area? What is the tree doing? Is it likely to grow further out because it's under stress? Is there anything within radius that might not be affected now, but as the tree becomes more mature and grows bigger, commensurately the roots will do something similar, that could be affected in the next year or two? And like with any preventative stuff, if we action it now, good and early, we're going to save ourselves a lot of work down the line. What's the expression? A stitch in time saves 9. It's the same with our trees. If we can spot an issue before it happens, we can make adjustments to local surrounding walkways, local parks, whatever it may be, in an attempt to avoid an accident or something bad happening. Also choose an appropriate tree species. Native trees seem to really like living in the UK. Non-native trees seem to want to invade their local area. You look at aspects such as knotweed, horsetail, these sort of invasive plants. Himalayan balsam is another one. So choosing more native trees generally have a more stable, predictable growth type. And it also means, typically speaking, they're more used to British weather, which means the miserable British weather, right? Which means often they're more drought tolerant and they don't go crazy with their root growth in an attempt to get food and water because they know tough times come, good times come. They're a bit more stable with it. Again, our tree choice can really make a huge impact on how we preventatively and proactively protect people. And then control measures, there's aspects such as root barriers. There's also aspects such as pruning, which can control the growth of the tree and therefore de-stress the tree and therefore make the root growth more predictable. These things are tools we can use. They're not the gold standard when it comes to our proactive measures, but they can help. Going back to our car, so we said pre stuff, we can make our car safe. What's the other stuff we can do? Well, making sure the driver is in a really, really good position, right? If the driver is competent, capable, free of distractions, less likely to crash. So during our tree inspection regime, have we got trained arborists? Have we got someone who knows what they're doing? Do they also know what good looks like? It can be easy to say, go inspect those trees, but what's the benchmark? And if we're inspecting, say, 1,000 trees, have we got fluctuating standards? Some think that's good, some not. And therefore, we don't really have a basis to measure what good looks like. And obviously, that entirely incorporates the damage when it comes from roots. If you have an inspection regime policy, within that policy, what good is and what not so good is, and then trained people, you really are giving your inspection regime the very best chance of succeeding, and hopefully not, but if a claim does occur, you're giving yourself the best chance as well of defending it. And as we said, early identification of problematic root growth is always going to be key. Tree selection and placement is also very, very key. Can we move pathways? Can we move areas of high foot traffic, areas of walkways around trees, or can we move trees themselves when it comes to future planning and planting? I give you a great example. In January, I went sugar-free for the month. It was horrendous, but I went sugar-free for a month. But the one thing I did do is I moved myself from bakeries, the sweet shop in Lidl's, and also the chocolate drawer in my kitchen. If I was near them, disaster was going to occur, and I was not going to hit my goal. With our tree roots, are we moving them near walkways, near schools, near buildings, near utilities? Are we moving the utilities near trees that we know we can't remove because of TPOs? It's just obviously a recipe for disaster. Again, we can really proactively plan that ahead of time. And as we said, root barriers, if we can't protect ourselves in other ways, again, it's another option that's available to us. And then pavement reinforcements. There's aspects such as what we do when it comes to slips, trips and falls that's a really key part of our inspection regime and our tree safety management procedures, which is what are the pathways, what are the roads? Are they quite friendly and cooperative when it comes to root interference? For example, a block paving is a nightmare. It just goes up and down very, very easily if a tree root comes near it. But stuff like your organic meshing where grass grows through is very, very, very good when it comes to reducing that uneven surface over time. Again, it's part of our strategic approach. Why choose an option that doesn't work well with trees in a tree area when we can choose one that does work well? And then public awareness campaigns. This is really, really key. So you've got your arborists doing your inspections, you've got your experts going around doing what they need to do. Why not make the whole public, the whole council, tree experts? As we said, stitching time says nice, spotting an issue good and early with tree root, moving something, damaging something, affecting something, or potentially going to do so, can help us to save a lot of work down the road and a lot of risk down the road. Well, public awareness campaigns can mean that they are more likely to report or complain, I guess, issues before they happen or issues in their early stages. You can't be everywhere at all times, but the public seem to have a habit of doing so. So get them trained. Let them know what the channel is. Often members of the public know what good and not so good looks like, but they don't know how to report it. Also, warning signs in public areas, or if we think there's going to be an issue with tree roots in an area, warning signs displayed, again, can be good claims defensibility for you, where you've done your due diligence and your efforts in trying to protect members of the public. And then finally, what about with our car? Again, so we said pre-checks, we said keeping your driver competent. What happens if a crash does happen? Well, seatbelt, airbags, those sort of things will protect and reduce the likelihood of a crash becoming quite severe or quite bad. So when it comes to our aspects, have we got these sorts of things in place when it comes to proactive in an attempt to avoid something bad happening from becoming worse? So again, regular pruning, soil management, legal compliance, infrastructure planning, really, really key. One thing we've not identified with soil management is a tree will become more stressed if it becomes dry or if there's concrete around it where it can't get organic material. Things like mulching and proper soil maintenance can mean that the tree's really, really healthy. If the sun's beating down on bare exposed soil, it's going to dry very quickly. It's going to crack, and then the roots are going to grow even further in an attempt to get their dinner. Things like mulching can keep moisture and nutrients locked into the ground far, far longer. This means the tree roots will become a lot more compact and less expansive. And in an attempt, the tree will continue to grow in a healthy way, but the roots won't impact further than what we hope they would be. And then incident response plans. So establishing protocols in readiness of something happening, a slip, a trip, a fall, damage to the environment, damage to property, damage to utilities. If these things happen, questions such as, now what, is much too late. That's the sort of question you should be asking in a round table as you go through scenarios. Okay, tree roots interrupt services. Tree roots lift a pathway so badly someone trips. So now what do we do? Well, we do these things. Then you document it, you train it out, and now and again you practice it. In doing so, if something bad happens, you're a well-oiled machine rather than maybe running around like headless chickens wondering what to do. We do our very best to avoid incidents from occurring, and as with anything, unless it's documented, it doesn't exist, at least legally. So make sure all that's wrote down, so we're in a good place. But if these things do fail, or if there's something that slips through the cracks in some way, you're a well-oiled machine in proactive management of an accident occurring or something bad occurring. So damage to tree roots can be significant, but it's entirely controllable. Proactive measures such as your inspection regimes, planned maintenance, planting, strategic planting, documenting all that is really, really good. Competency inspectors and those performing the works and giving them a set and written benchmark of what good looks like is very important. It's all well and good presuming they know, but do you have a way of proving it? Encourage community involvement and warning wherever you can, and also reactive monitoring systems in place, such as complaints procedures, your accident investigation response, all that sort of stuff before it occurs will give yourself the best possible chance of defending yourselves and also learning lessons, key, valuable lessons for the future when it comes to tree root liability.
Right, thanks, Will, Natasha, Luke. Yeah, very interesting, and yeah, really appreciate your time for that. Now we've got quite a few questions, so we'll try and get through as many as we can, and the rest, if we don't get to, we will follow up when we send out the recordings later on. There is a QR code on the screen, and if you want to scan that will access the feedback form for today's webinar, but we will also send out a link to the feedback form as well when we send out the recording. So got a couple of questions here, so I think probably this might be well, I'll just put it out there. So can a claimant's tardiness in reporting property damage to their insurers, resulting in a claim to the tree owner 3 years after the claimant first noticed wall cracks, result in a failure to mitigate argument and a resultant reduction in the value of the claim?
So happy to take that one, Dan. So all homeowners and claimants should really act as the prudent party, and of course they have a duty to keep their costs to a minimum. But what you can often find on these types of claims are you dealing with litigants and persons or individuals who don't actually know possibly what the cause of the damage is. So courts will be sympathetic to that point of view. The best argument in those circumstances is clearly after the 3 years has passed and a claim is presented to you, is that you have the defence that you were not aware that there's a real risk of damage being caused to their property by that tree. And therefore, that damage that has occurred prior to you being placed on notice is not something that you would be legally liable for. And it would be only the damage that arises thereafter, if it is proven causatively that your tree is causing damage and you haven't sought to abate that nuisance or mitigate, would only be possible for the third party to say, okay, well, we will claim therefore for the additional damage that may have occurred after that time. Because with claims of nuisance in particular, it is a continuing tort. So every day the nuisance occurs, the statutory limitation of 6 years for property damage starts again. But what you see is that if the damage occurred 7 years ago, that would be statute barred. but any new damage occurring within the 6 years could be claimed for. But of course, the responsibility would again be on the third party to show that there's been an increase in the actual cost of the repairs in those circumstances for new damage for which you, once you've been put on notice, would be responsible for.
Right, thanks, Will. So the next question, I think this might be one for sort of you, Luke, but I'm sure you probably all got a view on it. So recently, we have seen an increase in residents asking for trees to be removed because insurance companies have increased their premiums purely because a tree is within proximity to a house, regardless of any specific reasoning. What can local authorities do to convince people that the removal of a tree is not the answer, especially considering the report mentioned earlier that pruning does not help with root-related issues, or to convince insurers that trees are maintained and surveyed for safety concerns and the increased premiums are unwarranted? So basically, I read that as what can local authorities do to basically convince residents that they've got appropriate stuff in place to manage, obviously, the risk of tree root damage.
Yeah, so one aspect I would say is public awareness as well. If it the other thing is evidence is key, right? It's irrefutable. So if you can go in with a report of some kind where you've assessed the tree that someone's complaining about, I guess, and given evidence that, you know what, there's a bigger case study and a bigger evidence for it to stay than not, then they've got something to take to their insurers, I guess. But also the fact that it's not a haphazard approach. I think often when it comes to members of the public, if they think it's, how do I word this simply? If they think it's stupid or lazy, they'll kick off. So if something appears methodically and logically thought through, and you've taken the time to assess their situation and their, I suppose, subject matter, the tree in question or trees in question, they're more likely to be satisfied with you've just fobbed them off. Generally speaking as well, going with an approach of removing a tree is a last resort, and that's our policy unless there's justification, and again in this instance we can't justify it, but there would have to be justifiable evidence that the tree or the tree roots themselves are going to cause significant damage. Again, can we put that on potentially on them as a member of the public? Can you evidence that the tree is an issue beyond it's just a concern, or premiums might go up a touch? Yeah, that'd be an approach I would give. Anything documented, anything justifiable really gives you at least grounding to defend your case of trying not to remove trees haphazardly or without due cause, I guess.
Right. Thank you, Luke. Right. Okay. Got one here. Is working for a housing association, we get a lot of claims from homeowners stating trees on our land are causing structural issues to their property. In cases such as this, who is responsible for proving this? Should homeowners arrange a subsidence report via their house insurance? Are other housing associations responsible to get this report carried out? And I suppose that probably brings into the question really, so how do legal responsibilities differ between private homeowners and local authorities when tree roots cause damage?
So the onus is always upon the claimant to prove their claim, prove causation, to show that there's a legal liability. When somebody's telling you that your tree is causing damage, but they haven't provided you with any evidence of that, certainly you should be advising them, well, this is the evidence that we will need from you, be that an engineering report or an arboriculturist report, but certainly documentation to support your claim. It's not for you as the defendant to finance that. But what I would say is that once your neighbour has started speaking to you, please do something. As Lucas mentioned, you should have a process in place where, as a minimum, you go out and you take a look at that tree and give considerations as to should it be pruned, or is there any evidence that to the lay person may suggest that the tree could be an influence, and if it is, should you do something? Now, going out and doing nothing may be the only viable option, but at least you can say the issue has not been ignored. We've acted as the prudent owner of that tree and taken the complaint seriously. But as we see things on the ground, as our tree officer has reviewed matters, the evidence is not currently available for us to remove what is a healthy tree and with an amenity value in the area. I hope that helps.
Yeah. Right. Thank you, Will. Right, okay. Got about 4 minutes left. I'll try and do a couple more. We've got absolutely loads of questions, and we will follow these up. As I say, when we send out the recording, including some on particular topics that will require probably a bit more detail than the time we've got left to us. What are your views on a claim where it is alleged that highway tree roots have caused damage to a private drainage system? I have argued that this will only happen where there is a weakness in the system and that the roots have subsequently exploited, but the claimant is threatening to issue. Sorry, Natasha, I think you're on mute.
Sorry. Yeah, happy to take that one. Yeah, absolutely. My argument to that is that tree roots can only penetrate drains that are potentially damaged or weakened. There's certainly no foreseeability there. You wouldn't reasonably foresee the drains being impacted by tree roots, and it's certainly a situation that you would look to issue a defence on unless they can prove otherwise. Do you agree, William?
I do. I think, as Luke said, the tree will look for water. It will go to the easiest source of that water, and if it's a broken drain, it will head towards that and enter it to get the water out. So yeah, more often than not, the drain is damaged before the tree root comes anywhere near it.
Right. That helps.
Okay, thank you very much. Right, okay. So I'm just obviously conscious of time. Again, we've got 28 questions today, which is absolutely great, and we will follow these up. But okay, so how often should local authorities update their tree risk management strategy, especially in the light of case law or new subsidence trends like potentially 2025?
I would say it's good to have it depends on the risk of your area and what's going on, how complex it is, I guess. It's always good to have a periodic date in mind. I think anything longer than annually is probably not sufficient, even for a lower risk area. And then, like anything from a safety management procedure perspective, annually as a base. But if there's significant change, an accident, incident, anything along those lines, a near miss, a complaints report, you probably want to go back and review it. Again, having that documented within your management procedures, that's the stance, periodically. And then on the event of a change or accident, incident, or near miss, is a really good evidence that you are proactively and continually improving standards across the board.
Yeah, I would just echo that and say, obviously, Bexley v Robbins dealt with the hotspot areas, so everybody appreciates that local authorities have finite resources. So the key is to identify hotspot areas in particular where you see tree root damage claims arising more often than not, and to place your resource there. That's not to ignore the others, but it's simply to obviously demonstrate that you manage that risk and you've identified where the real risk lies, and that's where resource is being placed. And as Lucas mentioned, to ensure that records are kept securely and they know where they're being kept in the event that a claim is being presented for defensibility options.
Brilliant. Right, thank you. Okay, so yeah, no, that obviously that's brought us up to time. As I say, there's absolutely loads of questions. We're up to 33, so apologies we haven't had an opportunity to address these all now. We will make sure when we send out the follow-up, obviously, to all attendees, that obviously you've got those, and yes, that the content will be available to you when we send those out. So I really appreciate you joining the session. Thanks obviously for all your questions, still coming in thick and fast, so thank you very much. And yeah, just had a comment, basically think a further session would be helpful given a number of questions, very interesting. So yeah, thank you for that feedback, and yeah, we're looking to see what we can do. But in the meantime, I would just like to thank Natasha, William and Luke, obviously for running through this with us today. And yeah, we will follow this up in due course. So thank you ever so much for your time, and enjoy the rest of the day. So thank you ever so much. Thank you.
Thanks a lot. Bye.
Cheers. Bye.